I'm going to start out with, first of all, you have a hard copy of all my slides, and we may not get to some of those at the end. We'll just see how time goes, but I think the important things I've tried to put up front. And starting out, often I get accused of not giving you good news. I just scare the daylights out of you. So my goal here today was to start with good news. And not often do I get to say that nuisance lawsuits are good news. But in 2008, and I've been doing this line of work ever since I quit milking cows and went to law school back in the late 80s, early 90s, and I've followed, nuisance cases have, hopefully 2009 won't bring something, hopefully we're seeing a turn in the tide, so to speak. But we've had 3 nuisance cases in 2008. I talked about a couple of them last year because they happened right at the time of Pork Congress, but of these 3 nuisance cases, all of them that went to trial that I know of against livestock operations last year in the state of Iowa, the jury returned a verdict of no nuisance as far as odor. So that is something that I think is great for the livestock industry in Iowa, and I hope it continues, and I hope what it means is we're doing a good job out there. Even though these operations were sued, and you never want that to happen, but they got a good result when they went to trial. And let's just talk about it a little bit. First of all, the Wood versus Schott case out of Cedar County, 100-cow dry lot cow-calf operation, maybe a little unusual and not the normal the normal situation for our livestock operations, but the jury heard the evidence that the neighbors were claiming that this was a nuisance. The cows were only in there from March to May. But the important thing about this case is the jury actually awarded $30,000 to the livestock producer for attorney's fees because they found, and I put it in quotes, it's right out of the jury instructions, because of the use of the legal process for an improper purpose. And one of the main questions I get from producers when they find out they've been sued for nuisance or could be is, can I get my attorney's fees paid if we win? And most attorneys, me included, the answer we will give you is no. Our legal system is based on each party pays their own fees. Well, there is a provision in the law which is rarely used where if the judge or jury finds that the other party was using it for an improper purpose, harassment, there was no foundation or legal or no factual basis for what the claim they're bringing, they can do this. And this jury heard the evidence and ruled that they had not brought a claim properly and awarded $30,000 for attorney's fees. A very significant case, and I've gotten a lot of questions from other attorneys in Iowa. I wasn't the attorney on the case, but I've received a lot of questions about this. And again, very important. Okay, next case. Actually, the jury verdict in this case came out on Wednesday of Pork Congress last year, so I didn't get a chance to talk about it in this seminar because I got word of it right after I got done with this seminar last year. The camps had a 300-head hog operation in Madison County. Trial was moved to Polk County. You've heard about this case for several years before it was decided. The jury found that it was not a nuisance. And I think one of the significant factors here, along with the fact that that last bullet point, the jury rejected Tetzloff's claims that camps surface spreading of manure from his pit from a 300-head hog building had caused their daughter brain damage. The jury rejected that claim, found not a nuisance. To me, the key here is we were in Polk County, folks, with this jury. This was a Des Moines, Polk County jury that decided a hog nuisance case. And we were able to talk to some of the jurors afterwards, which you can do. And the jurors, luckily we had a few, for the livestock producer, we had a couple jurors on there who had a farm background. And they just didn't believe the plaintiffs presented a case, the plaintiffs being the Tetzloffs. They did not believe they had presented a claim for nuisance. And again, it was laid in front of them, and they just determined that it was not a nuisance. So they awarded a 0. Nothing for damages. Okay, now we move to a case that was just decided in November. Go way up north, far northwest county of the state. The case was Homus versus Rock River Feed Yards, again in Lyon County. This is one, I don't know if any of you remember, a few years ago I was asked to be on Iowa Press to, in effect, I'll call it a debate, have a discussion with Jeff Vonk, then the director of Iowa DNR, about local control and things like that. David Yepsen, who was one of the reporters on Iowa Press, asked me about nuisance cases, etc., which is not really why we were there. But I gave the example of a nuisance case that had just been filed. That was in 2006. But the point Mr. Yepsen made was, aren't all of our nuisance cases a result of people moving out from town? They just don't understand the country, etc. And I said, well, Mr. Yepsen, yes, but we just had a case filed a couple days ago, and that was true at the time, where a pork producer sued a cattle producer for nuisance. And I don't know how many of you watch Iowa Press, but they have the different camera angles. And when I said that, the camera was on me, and what the camera didn't show was both reporters, Yepsen and Glover, leaning back in their chairs, literally laughing when I said that. And it never showed up on camera, but they could not, it was a real surprise to them that we could have one livestock producer suing another. That was this case. Well, as lawsuits often do, they take a long time. This went to trial in November. 6,500 head cattle feedlot. Mr. Homus and his wife live less than 1,000 feet from a 6-acre feedlot runoff basin. The situation was this feedlot had not been required to have a runoff basin until the EPA and DNR regulations were either changed, depending on who you ask, or more strictly enforced, and they had to put a basin in. 6-acre basin. That, and the only way, with open feedlots, you have a little trouble finding where to make them work, etc. They actually have to pump to that basin, but the best place to place it was less than 1,000 feet from their house. They felt that it was a nuisance from odor, and that basin has a center pivot system that runs with it. The Homuses have a 500-head swine nursery right on their farm place, and then a half-mile down the road they have a 1,000-head deep pit finisher. We went to jury trial, and the jury returned a verdict of no nuisance for odor. They gave a 0 for the claims of odor from the basin and the center pivot and the feedlot. I've got plenty to cover here, so I won't dwell on this too much, but there was testimony from homeless witnesses of the odor being very bad from the basin, testimony that the hog odor from their hog buildings was a normal farm smell. They did not find that objectionable, but the cattle feedlot basin was very objectionable. Witnesses for the Rock River feed yards presented testimony including a mail carrier, a UPS driver, and another neighbor that lived just about as close as the Homuses, and they testified that that odor was no different than any other farm smell. And those of you from that area, or if you've been to Lyon County, you know how many livestock are in Lyon County. Again, the jury found no nuisance to odor. Now, the last bullet point, there was another issue here, which I want to be fair in reporting this to you. In the spring of 2007, those of you from western Iowa, or Iowa, know we had a very large snowstorm, and 17 inches, something like that. And the feed yard, a couple days after that, had to clean off their feed aprons by the feed bunks. And looking back, they realized it wasn't the thing to do, but they had to get it out. They spread it on top of snow on this hillside. That hillside drains away from the Homus property normally, but there was a big old snowbank that went across as it came around the hillside. We got a very rapid snow melt that day, or the next day, and when it melted, the runoff could not go where it usually goes because of the snowbank, and that was shot right over onto the Homus property, and they got water in their basement, and they testified there was manure in that water. The jury found that that did cause the Homuses damages to their basement and awarded $40,000 for that event, for loss of use and enjoyment, a nuisance for the water in their basement, and damage. So, there. I've told you about the case. Those are the 3 nuisance cases we had in Iowa last year. Any questions about that? Again, I know maybe it's not a typical situation for those of you with deep pit hog buildings, but again, I think it's very good news for the livestock industry that juries have returned verdicts recognizing that livestock does have some odor, but they found that it was not a nuisance. Again, any questions there? All right, now let's move on. There was another case that went to the Iowa Supreme Court on whether a sow unit could be determined to be a nuisance before it was ever built and operated. This is out of Kossuth County. And the Iowa Supreme Court denied the request for an injunction to stop construction of this sow unit. Again, the claim is, Judge, don't let them build it. We know it's going to be a nuisance. Just don't even let them build it. Give me an injunction before they ever build it. And the Iowa Supreme Court denied that request and said there was no evidence that a nuisance would clearly and necessarily result. That had been the law before. There was some concern that maybe the Supreme Court would change the law, but they did not. They stuck to it. So again, a good, positive decision for the livestock industry in Iowa. Nuisance, probably one of the last things I want to talk about here is what can you do to protect yourself? I've talked about this in years past. I'll talk about it again. I'm not selling insurance, but please, if you're producing livestock in Iowa, take a look at nuisance insurance, because your standard farm liability policies, without some special policy or a special rider, 9 times out of 10 will not cover nuisance. Okay? And you do have, you can talk to some of these people who have went through nuisance cases, and my clients included would say, well, we won the case, but we still lost because we had to pay McAfee and his cohorts. Legal fees, we know how high they are. Nuisance insurance will cover those. So again, look into your policy that you have now if this is of concern and see if it's covered. If not, there are policies out there that will do it. Again, I'm not selling it. I'm just trying to help you with risk protection. Steps to help avoid a lawsuit. I'm not going to spend a whole lot of time on that so that we can move on to some of these other issues. But these are things that we all look at doing in our operations. Don't overlook this. Even if you have insurance, don't overlook these things. Separation distance. There is no substitute for being as far away from people as you can. Sometimes you can't be. You take that into account. Prevailing winds, we have to look at that. And many of you have worked with the Coalition to support Iowa's farmers and their use of the Iowa State CAM model. That's C-A-M. It's a computer model where you can model these sites before you build. Take a look at that. It takes these things into account. Tree buffers. Look at existing trees. What's already there? Plant some trees of your own. Again, I think this is one of the things that neighbors will tell you, oh, trees aren't going to do any good. You're not going to satisfy a lot of people by planting trees if they're opposed to your site anyway. But I think in the end, give them a few years, and the fast-growing trees, os trees, other types of fast-growing trees, within a couple of years you can have 20 to 30-foot tall trees that give you a good screen. The experts call it visual screening. Myself, I think, and a lot of others would say, what, out of sight, out of mind? And I would never suggest that anybody smells with their eyes. But visual screening. It also, the research shows, helps give you the chimney effect. The wind coming, hits those trees, shoots it up, just gives you some sort of break in those breezes that can carry odors to the neighbors. Biofilters, we could talk for a half an hour on biofilters. Take a look at those, what's out there. I'm sure we have some vendors upstairs that can provide you with options for biofilters. That next bullet point, clean pigs in buildings. And those of you who have heard me talk before know that I emphasize this. Research shows that a lot of the odor, and when we have problems at a site, a lot of the odor can come from above the slats, not below. And the fully slatted floors, or whatever system you're using with good ventilation, keeping those pigs comfortable, gets that manure down in the pit, not up there where they can lay in it. And partially slatted floors, whatever you use, good ventilation, keeping those pigs comfortable is important. And I've went round and round with plaintiffs' attorneys, those representing the neighbors, that, oh, you spend all this money on these ventilation systems to keep that pig comfortable, and you don't give a hoot about the neighbor and spending money to reduce odor. And that's where I believe they're wrong, and I've told them they're wrong. The money you spend on keeping that pig comfortable also helps with odor control, and I think we need to keep emphasizing that. Manure treatments and additives, those have been out there for years. We see new ones every year. Just keep an eye on those and see if there's any that work for your operation. And then, of course, manure agitation and application, I don't think anybody can deny that's where we see a spike in the odors. It's something, and the benefit we have with the manure storage systems we have today is we don't have to do it as often, and you just got to do your best to try and plan those activities when you can have the least impact on the neighbors. But we all know what a challenging fall this was last year just to get the darn stuff out of there. With weather and everything, sometimes you have no choice. Communication with the neighbors when you're going to apply manure, all of this is key. I can't point to anything on that list and say, you do that and you won't get sued for nuisance. Because some of the cases we see, and we've got about, I think, 5 cases pending right now in Iowa courts, they probably do all or most all of those things. Sometimes you're just, how can I say it because I'm being taped? Sometimes you're just in the wrong place at maybe the right time. I don't know. Anyway, you've just, again, I can't point to any of these things you can do and avoid a nuisance suit, but what I can say, if you've got neighbors that are concerned and you don't do some of these things, you're going to have a bigger problem. So do the best you can, and many times it'll work out for you. Any question on any of the nuisance discussion? Okay. Before we get to the air emissions reporting, I want to talk for a few minutes about the EPA Final CAFO Rule. Before the air emissions reporting came out, or became a big issue here in the last 2 weeks, this was going to be the big part of my presentation, and that is, and many of you know this is not state regulation. Now we're talking about federal EPA. For several years, EPA has been working on this CAFO rule. Several is an understatement. When did it first come out? The final rule came out in 2003. We were working on a proposed rule before that. The final rule, quote unquote, not so final rule, came out in 2003. It goes to court. The court in 2005 says, EPA, you can't make people get an NPDES permit or a discharge permit because you think they're going to discharge, or make them show that they have no potential to discharge. The court said you can't do that. EPA has to go back to the drawing board and comes out with another proposed rule, then sent out another one. Anyway, you get the picture. Finally, the rule came out, and I can kind of cut to the chase, but I do need to go through some details here. That in Iowa, with our confinement feeding operations for hog operations, and we've got Mr. Gene Tinker. I'm going to pick on him like I usually do. He's trying to stand in back and be inconspicuous, but I spotted him. Gene, raise your hand. Gene's with the Iowa DNR, and I talked to Gene the other day to what is this, the question I get from producers, what is the final CAFO rule going to require Iowa livestock confinement operations to do differently than we're doing right now are we going to be required to get an NPDES permit? And Gene, the answer to that question is? No. All right. Couldn't have said it better myself. Iowa has, and has had for years, a standard for confinement operations is that you must retain all manure in the manure storage structures between periods of manure application. It's pretty clear. It's a pretty strict standard. You can't let anything get away. And so why would you need a discharge permit if you can't discharge? Now, some other people would say it a little differently than I just did, but I think that captures it. And I think that's what Iowa DNR is recognizing, right? And that's what I think, so far, EPA has not suggested that we need to do anything differently in Iowa. Is that accurate, Gene? Yep. Okay. So, I think this still comes under the heading of good news for confinement producers. We don't need to be looking at an NPDES permit. Now, there's a few details we need to get into here. And Well, we'll get into those. Any questions about that general statement? Because I know a lot of you are wondering, what do we need to do? I get questions from attorneys from other states, or what are you doing? Did you have something, Gene? Or? Yeah, we'll get there. You need a copy of the slides. Okay. Gene always concentrates on me. So, well, let's move right to that. Well, wait a minute. I want to back up there a second. I said you don't need an NPDES permit. Gene has said you don't need an NPDES permit because you can't discharge. Now, if you're an open feedlot of any kind, the discussion we're having right here does not apply necessarily, because an open feedlot in Iowa can, depending on the size, can have a discharge under Iowa law, and then could be subject to being required to have an NPDES permit, and we could get into a lot of that discussion. What I want to point out there is the bottom bullet point there. Without an NPDES permit under federal law, you cannot have a discharge, period. If you're above the 2,500 head hog operation and you don't have an NPDES permit, you're not allowed to discharge at all. What a discharge permit lets you do is you have to design it to retain the 25-year, 24-hour storm. If you design it for that and you get over the 25-year, 24-hour storm and have a discharge because of that, and if you properly operated it and maintained it, then you're in compliance with your permit and you're in compliance with federal law, even if you have a discharge. However, for confinement operations in Iowa, you'd be in violation of state law, because state law doesn't give you that break as a confinement operation. Even in a large storm, you are still required to retain all that manure. So therefore, that's why we say you don't need a discharge permit in Iowa. The benefit, say you're an open feedlot operation, and we could talk about this for quite a while, but we're not going to. We've got other things to cover. Some open feedlot operations will take the position that I'm not going to discharge because of the way the land, and I've got a long ways to a creek, etc. They can do that. They're not required to get an NPDES permit as long as they don't discharge. But if we get the storm of all storms like we had last summer, and that open feedlot discharges without a permit, they are in violation of both Iowa and federal law. What would happen if they had an NPDES permit? They would be protected if they were properly operated, designed to hold the 25-year, 24-hour storm, and it was greater than that, then they'd be okay if they had a permit. So what I'm trying to say is, if you're an open feedlot, you're taking a risk by not getting an NPDES permit, because you don't get the protection of the permit if you get the large storm. You have to hold it no matter what. Confinement operations, I don't think that's an issue. If you've got outside storage, a lagoon, etc., I think the key there is to make sure you don't have any surface runoff going into that lagoon. Keep the surface runoff diverted away from that lagoon so that all that goes into it is what comes out of that building or what falls out of the sky. Then you should be okay. Any questions about that? What about land application? Isn't land application, if you have a discharge when you land apply manure, is that considered a discharge that you need an NPDES permit for? Yes. But there's an exemption, and I don't give you a lot of detail here. And any of you with questions about this, I'd be glad to give you more information. The federal rule has an exemption for ag stormwater discharges, which in a nutshell says if you have a site-specific nutrient management plan, that's the federal term, and don't use that literally here, it's just if you have a manure management plan that's site-specific for your operation, and you apply according to that plan, and then we get a storm or a precipitation event that causes runoff because of the land application. If you followed your manure management plan, a site-specific nutrient management plan, it's considered an ag stormwater discharge, and that's exempt. Now, Gene, I'm going to put you on the spot again. Is DNR looking at anything about the ag stormwater discharge differently than what we're doing now? Okay. You realize Gene's on tape along with me here too, so we'll... No, the stormwater discharges, again, looking at that, is there some difference between that site-specific nutrient management plan that federal law has a nutrient management plan and Iowa manure management plans. Yeah, maybe a few differences here or there. But in my reading of the law, and apparently DNR's too, the Iowa manure management plan is almost identical, if not identical, to what you need under federal law to qualify for the ag stormwater discharges. Okay, so far again, you don't need an NPDES permit yet if you're a confinement operation. What about an accidental discharge? You're applying manure, hose breaks. Nobody wants that to happen, but it does happen. You have a discharge to a water. Maybe you turn it in, DNR comes out, there are elevated levels of ammonia, or neighbor turns it in, or you kill some fish. Again, nobody wants this to happen, but does that then require you to have an NPDES permit? Here's what the federal rule says. If the cause of an accidental discharge that has occurred in the past, so you didn't have an NPDES permit, this happens now. Do you need to get one in the future? So if the discharge that has occurred in the past, if the cause has been changed or corrected, the KFO would not be considered to discharge or propose to discharge, and an NPDES permit would not be required due to the accidental discharge. Okay. Gene, are we okay? All right. So, hose breaks, you have a discharge. What do? You fix the hose, obviously, but maybe you put procedures in place in a memo in your file with your records on site to say, this happened, but here's what we're doing differently to make sure that doesn't happen again. You should be okay and not be required to have an NPDES permit. Okay. Now, here's what I think some of you have some questions on, and this is the no discharge certification option. This was put in the final rule, and here's what EPA said. All right, you've determined you don't need an NPDES permit, but you're still a little uneasy about all this, so you can now certify to DNR and EPA, we'll get into that in a minute, that, and the key point there is voluntary. You're not getting an NPDES permit, you're voluntarily certifying that you do not discharge or propose to discharge. That's the standard under federal law, that you don't discharge or propose to discharge. So you've made that determination, you don't need an NPDES permit, but you still want some more protection. They established this no discharge certification option. The next slide will tell us what you have to do, or an overview, but why would you do that? Why would I do this? What's it going to give me as a benefit? Because it's not a permit. You still have to not discharge even in the large storms. What it gives you is, if a discharge occurs, you can be penalized for the discharge, the pollution of the water, the fish kill, etc. But you cannot be penalized for the failure to have an NPDES permit, because if DNR or EPA brings an action and they determine you didn't have an NPDES permit, should have had one, you can, they believe anyway, and I know you're shocked, but I don't agree with them on whether they can fine you for not having an NPDES permit, but we'll talk about that some other day. But this gives you protection for penalties for failure to have an NPDES permit. That's all it gives you. It doesn't protect you if you actually have the discharge for any penalties from having the discharge. It also, if the discharge occurs without an NPDES permit or this certification, you have the burden to prove that you did not discharge or propose to discharge. That's lawyer stuff. It's the burden of proof, and sometimes it can be important. But that's what you get for doing this voluntary certification. In this voluntary certification, EPA and DNR do not review the certification. What you have to do, the rule says, do a technical evaluation of your site. You must have a signed certification statement, and the statement must be submitted to DNR. Has anybody looked into doing this? Okay, that's what you came here today for. Let me see. Whoop, I need to go back. Okay, let's go to, well, I don't mean to just ask Gene to, my take on the no discharge certification, maybe, I think I come to the same place where Gene is, but maybe for a different reason. I've went through the requirements, and I didn't lay all those out for you. Let's see, I am on tape, right? what a quagmire. And I don't know, maybe some of you have been through it. By the time you get done doing all that no discharge certification, in my opinion, just get an NPDES permit if that's what and maybe I'm not being fair to the process because I haven't actually done it, but by the time I tracked it all the way through the regulations on what you have to do for that technical evaluation, in my opinion, you're all the way to an NPDES permit anyway, and see, you don't get the protection of an NPDES permit with a no discharge certification. So I come to the same place as Gene. So that's where it stands with that for right now. Now that rule is fairly new. I think we're going to see EPA may be issuing some guidance here at some point, or we're going to hear from other states. I would say stay tuned. But for right now in Iowa, you've heard what DNR is thinking, and I would agree regarding the no discharge certification. Okay? Okay. Now, we've got 25 minutes, and I'll be glad to spend all those 25 minutes talking about the next topic if we need to, and that is EPA air emissions reporting. Let's all, I got to take a deep breath here and kind of back up. What happened, and why all of a sudden were all of you told, what, about Friday the 16th or maybe Monday the 19th, you have to make a phone call by close of business January 20th, or you could be subject to $25,000 a day in penalties. And that gets your attention, doesn't it? Well, let's back up. And there's quite a few in this room who have been through this air consent agreement, etc. This air emissions reporting has been in place in the law since the early 80s, back when I was still milking cows, I guess, so I don't know when it was for sure. But for many, many years, EPA told us you do not need to do it for livestock farms. Then along came a case out of Kentucky that I refer to later in the slides against Tyson, where environmental groups sued Tyson for not reporting from their broiler operations in Kentucky, sued them for not making these air emissions reports. And the court said, yes, you do need to make those air emissions reports from livestock operations. Well, that hit the livestock industry pretty hard. National groups, including the National Pork Producers Council, got busy and worked with EPA to come up with the air consent agreement that we worked on in 2005 and 2006, where many of you signed up, paid a penalty or a fee to say, here I am, I probably should have been reporting, I wasn't, I signed this agreement, we're now, I pay this penalty, and now what we're going to do is do this air monitoring over the next few years to determine what's actually coming from these farms so we could actually report a number that we think is pretty accurate. So a lot of us thought that took care of it for a while. Then, and I worked on some reports for producers who didn't sign up, who actually filled out these reporting forms and made these phone calls in 2006, 2007. But in 2007 or so, they started working on a rule at EPA to exempt everybody from this reporting, everybody being livestock farms. So everybody, at least that I was familiar with, we all kind of put it on hold as far as doing these reports if you hadn't signed up for the agreement, waiting on this rule. The proposed rule exempted livestock farms, all of them, from everything. Sounded pretty good. Final rule comes out December 18th, 2008. Final rule exempts us from CERCLA reporting, okay, but exempted everyone, but did not exempt everyone from EPCRA, or the Emergency Planning and Community Right to Know Act. What it did, as you can see in the, let's see, that's in my next slide. This lays out the law, what you must report. And then I point out if you're in the EPA Air Compliance Consent Agreement, you were not required to report and are not until the monitoring study is done and they tell you what you need to do as part of that agreement. And there are exemptions to the law, and this is the new exemption. Wait a minute. There we go. The rule I just talked about established a new exemption, and I underlined the word exemption. From CERCLA, we have a complete exemption from CERCLA reporting. Well, you say, that sounds great, McAfee, but what happened to EPCRA? EPCRA, we didn't get in the final rule a complete exemption. We got an exemption for the smaller operations, but if you're CAFO size and above, you have to report. So that's what happened. That's why you're here today, I assume partly to hear why are we reporting now, but there's another piece to the puzzle. Why was it such a rush all at the end? We didn't hear anything about it on December 18th when it came out. The rule doesn't actually say that if you're above this level, you have to report by January 20th. What the rule says is you don't have an exemption if you're above those levels. So, and this is probably where I'll get myself into trouble, but it won't be the first time. I think it just kind of sat there a while at the national level. You get the holidays in there, etc., and I wasn't hearing much about, and I didn't think there was a January 20th deadline myself, because the rule just says the rule goes into effect on January 20th, which would mean as of January 20th, it's clear there is no exemption if you're larger than these amounts. Okay, that's what the law is. Well, somewhere in Washington, D.C., it was communicated that you better report, if you're larger than these numbers, you better report by January 20th or you could be subject to enforcement action. Now, it's my understanding at this time, EPA and the Iowa DNR has I've seen some of their reports they put out, that nobody ever said there was a January 20th deadline. I don't know. Somebody said it somewhere, and I can't tell you for sure who said it where, because, and I participated for the Iowa Pork Producers Association, working within our national group to get the word out that to be safe, you better get reported by the 20th, or because it's clear you don't have an exemption after that date, you could be subject to penalties. Does anybody believe that EPA was going to go out right away on the 21st and start fining people for not having reported? No, and I don't think EPA ever said that. The concern was citizen group lawsuits against large producers, etc., that once that exemption was clear, you didn't have it, if you're that large, and you hadn't reported, you could be exposed. That's where it came from. Any questions about how we got here? Okay? Is that what I said consistent with what you were hearing? All you heard was January 20th, right? And Martin Luther King Day was January 19th, so that gave you one day. How many here made the phone call? How many had somebody hang up on you? No, I'm just kidding. I actually heard one producer said the local person did hang up, just too busy. I don't know if that's true or not, but here, let's back up a second. Who needs to report? Number one, if you signed up for the air consent agreement, you do not need to make the phone call. Okay? Here's what I've run into. Some people made the phone call for signed up for the air consent agreement for their hog operation, but if they have a cattle operation on site, cattle did not participate in the air consent agreement. At least beef cattle did not. So I don't know of any open feedlots that signed up for the air consent agreement. So I have a couple of people I talked to who had signed up for the air consent agreement for their hog operation, but they went ahead and made the phone call for the cattle operation because they're covered under this. So that's the first group that doesn't have to do it. You signed up for the air consent agreement. Didn't have to make the phone call. You wait until they come out, they're done with the monitoring study, and then they're to get in touch with you and tell you what you need to do as far as any reporting. Okay. The other group that doesn't need to do it is if you're smaller than these numbers I have on the board. Now, I did take the liberty of not giving you the threshold for ducks. If there's anybody here that thinks they meet the duck threshold, I will be glad to get that number to you. Okay. Now, here's where I have a difference of opinion of what I've seen from, at least attributed to EPA. The question is, what if I have 900 cattle and 2,000 hogs on the same site? Okay? Do I need to do the reporting? Well, you don't have 2,500 head of swine, nor do you have 1,000 head of cattle. And I don't believe you need to report, but I've seen something attributed to somebody at Region 7 EPA in Kansas City where they say because that operation would probably emit more than 100 pounds of ammonia in a 24-hour period, on at least sometime in a 12-month period. They believe you need to report. I haven't had a chance to check that out. I read this rule like the KFO rule where you do not combine across species. You'd look at them separately. Gene, have you had any discussion on that? Or?
Not any discussion, but I would agree. You have to hit one of those limits before you have to report it. If you do hit one of those limits, you've got other animal types there that make it probably.
Here's the next thing, and I hope everyone can hear Gene. If you can't, raise your hand and I'll repeat it. The other thing is, this rule does, remember when we signed up for the air consent agreement, there was some question about, okay, if I've got a 2,400 head fisher, am I going to be above 100 pounds of ammonia or hydrogen sulfide in a 24-hour period? And that's what the air monitoring is supposed to tell us. But some of you signed up, I think, even if you were below the 2,500 head, because there's no bright line test or on numbers in the EPCA reporting requirements until we got this exemption. The way I read this exemption now is, even, let me say it this way, if you have a 2,400 head site and somebody could prove that you're emitting more than 100 pounds of ammonia in a 24-hour period at some time during a 12-month period, I read the rule that you still don't have to report because you have an exemption. It clearly says if you're below those numbers, you don't have to report. And so I don't know if any of you are in that category, but I'm a little concerned about some of what I'm reading where some people, and I need to track it down, at EPA still believe if you're emitting more than 100 pounds, this exemption doesn't cover you, and I don't believe that's the case. I believe if you're below 2,500 head of swine, I don't care what you're emitting, you're exempt from those reporting requirements. Best I can say is stay tuned. I think that's about what I wanted to cover on those animal numbers. If anybody has any questions, one question you might have is, what is a farm? Is it the Iowa adjacency requirement, etc.? I've been telling people to follow the Iowa adjacency requirement. EPA doesn't follow it literally. Gene, have you had any discussions? EPA, I think, is a little more lenient, allowing you to be closer together and be two separate sites than what Iowa law is. But I think you're safe right now just following the Iowa law requirements on what is one site or two in determining whether you meet these numbers. Okay. Let's stop a second here, and then we'll get to the nuts and bolts of how to do this, and I do need to keep moving. But who is potentially liable under EPCA reporting requirements? The question I had over those 3 or 4 day period was, who reports, the contract feeder or the owner of the pigs? Who makes that phone call? Well, I gave the standard lawyer answer. Both of you do it. Then you'll be sure you've got it covered. Okay, here's what the law says. The court in Kentucky in 2003 said the person who has to report is the operator. And an operator is a person who manages, directs, or conducts operations specifically related to pollution. Does that tell us anything? No. All right, contract feeding. Who is potentially liable if the report is not made? The contract grower clearly is. They're an owner or operator. You're the one out there taking care of the site. Clearly you're liable if the report is not made. How about the contractor, the one who owns the animals? What that court said was the owner of the animals in that case was liable because they managed and or directed many of the operations related to the venting of ammonia. They had field people who went around and checked on ventilation, etc. So that court said, in that case, Tyson was also liable. Now, do both of you need to make the phone call in the report? I don't think technically you do. One report should be made. Now, this is different than the EPA consent agreement. That one clearly said both of you have to do it if both of you want the protections. Here, I think only one report needs to be made. But what I advise people, and I think I talked to a few of you on Friday, Monday, Tuesday, somewhere in there, if one of you, or if neither one of you do it, then you both could be liable. So I think the best thing to do is both of you call in and report it to make sure it gets done. That's at least the best place to start. Okay? Any questions about contract feeder, who needs to make the report? Okay. I'm going to, let's see, I think I've got a slide. Yes, leased facilities, if you're a landlord, you own the buildings, but somebody else is renting your buildings and taking care of the pigs there, you as a landlord do not need to report because you are not an operator of that site unless there's something different about your lease. Okay? All right, what do you do? First of all, if you're in the category that has to report, you call the State Emergency Response Committee, that's the EPA language. In Iowa, it's the DNR, and that's the Emergency Spill Reporting Number. And I assume most of you did that. Gene, do you know how many calls DNR received? It was a bunch, I think. Anybody have trouble getting through? Okay. What do you do also? You call the local Emergency Response Committee. And you go to the EPA website, and it will tell you who that is. Did anybody have trouble finding your local emergency response number to call? Okay. I'm interested, what kind of response did you get when you called? Any examples here? Mike, I'll pick on you. What did you get?
Well, we just had clients get back to us, but a lot of it, we actually had a county call us on Thursday and asked us what the hell was going on. My guys are calling, and what am I supposed to do? Well, we didn't know what we're supposed to do. We called Eldon. But a lot of them, they would call back laughing because the person they called said, well, what am I supposed to do? And the guy in our time would say, we're just supposed to tell you we might have a deal. So it was quite confusing. And we told our guys that they're not going to know what's going on.
Everybody hear that? And I know many of you, IPPA sent out an email with a script of what to say. I know other groups did too. If you need any of that information, first of all, I'll interrupt myself here. If you haven't made the phone call, DNR sent out an email, and I would agree. If you're in this category where you should be reporting this and you haven't done it yet, go ahead and make the phone call. Don't say, well, I missed the 20th, I better keep quiet. I'll leave it up to you whether you think you need to do this or not. But don't stop making the phone call now, even though it's past the 20th. Clearly, that 20th was not a hard and fast deadline by any stretch. We sent an email out, and if you didn't get that, it's on I've got the IPPA website here later. It's got a script of what you say, and in that script nowhere was there anything that said, I'm emitting so much or whatever. It truly is just a notification requirement. What all this is designed to do, just like the name of the statute says, emergency reporting. And there is a provision for continuous releases, which are considered emergency. This is where I'll likely get myself into trouble, but I think it's ridiculous that we have to report from livestock farms, okay? But the law is the law, and we have to do it. I think, as an example, like Mike said and others, you call those local people who this number is supposed to be for reporting emergencies. And they get the phone call, and, okay, you've got 2,600 head of hogs. Okay, what's the problem? What am I supposed to do? Well, you read the script, and it just says, the law says I call you. That's it. What do they do with it? They do nothing with it. They make a note that you called, and that's it. Same as with DNR. They make a note that you called. They give you a number, don't they? Did they give you a number?
Somebody would contact you.
Okay. The gentleman here just said somebody would contact it. DNR told you that? Okay.
Over the weekend, they would just tell you, the field office will call you back. So they took your name and number, then the field office you lived in called you back several hours later.
You should have been, did everybody hear that? You should have been given a response number of some kind. If not, they'll get back in touch with you, I assume. Gene, is that, again, I'm picking on you. Maybe you're not dealing with this much.
This sounds kind of silly, but you get a spill.
Right.
So if you didn't have a spill, you get a spill. But every operation they call in, you get a spill.
And in fairness to DNR here, Gene, you didn't have a heads up this was coming either, right? Okay. So this caught a lot of people. And I think, and I'll say this so it can be attributed to me, I understand that phone calls were made to Region 7 EPA, and some people at Region 7 EPA didn't know this was coming. But, all right. Now here's probably what we're about 10 minutes away from the end, and you probably want to know, what do we do next? This follow-up, the written report within 30 days. Now, in the email that IPPA sent out, and again, if you didn't get that, you can go to the website, or you may have gotten it from somebody else. I know a lot of emails were sent out, but there's an example written report there. My advice is don't send it in yet. Hold on, because, and I checked the rule again, and I circled it and started in my copy, of the rule that was issued on December 18th, it says EPA is to issue guidance on this report. As of yet, I have not seen any guidance on that. My advice would be you have 30 days to do it. Don't lose track of the 30 days, but my advice would be don't get in a hurry about sending this written report in. Now, I've done some of these written reports before. As I told you, we've been filing some of these reports back in after the air consent agreement closed. And I'll be working with IPPA to give you as much direction as we can. What I think we need to do, and we developed some language that you do as an attachment that says, and we're not ready to put it out yet because we want to see the EPA guidance first, but essentially what I think we need to say is we're estimating what these emissions are, and I think you got some of the information from ISU and Nebraska how to estimate those, but clearly say it's an estimate, and we're kind of waiting on this air monitoring study that's still got, what, a couple years to go yet or whatever, that these are our estimates right now, give them an upper bound and a lower bound and all that stuff, and just say, but these are purely estimates because the whole reason to do the air consent agreement was, for those who signed up and those who didn't, was to give us a better idea of what's being emitted. So, again, we'll be working with others, IPPA and other organizations, to get you the best information we can to help you with filing that written report. Anybody else have thoughts on the written report? Again, keep that date on your calendar. It's starred on mine, and we hope to have something out to everybody a week in advance, etc., of when that deadline is. Okay? The question was, in the information you received, I assume from either us or regarding swine, you did not get anything about hydrogen sulfide. My understanding is that that hydrogen sulfide is not an issue for meeting the 100 pounds limit reporting requirement, so that's why you didn't get any information there. Now, that's not the case for some other species, but for swine it is. That's my understanding. So that's why you only got information on ammonia. Yes? Everybody hear the question? The answer is, it provides you protection going forward from the date you make the phone call. Could you be found to be liable for not reporting prior to that? Yes. Now, I'll be glad to add, I'm not just throwing these answers out. I think maybe where you're going with this question is, if I could be found liable for not reporting previously, would I be better off laying back and not reporting? Have I just turned myself in other words? You never want to say never, and I've dealt with EPA for a long time, but I don't think that's going to happen. And now you're sitting in there as chair saying, wait a minute, that's why I signed up for the consent agreement and paid that money, is to protect myself from any past violations. Why should somebody be able to make a phone call and be okay? So I can't say for sure what's going to happen. For sure, if you're a new site that could not do the air consent agreement, then you had no option other than to report. Go ahead. No, it transfers. The agreement says right in it, it's assigned, and whoever bought that operation is subject to that air consent agreement. So yes, it transfers. No. I didn't. I was going to say I can answer that one quickly. No. Wait a minute. You think you're going to get a refund from the federal government? The question was, if you purchase a site that did not sign up, is the new buyer liable for the period of time prior to you buying it for any penalties? I don't think you are. Can I point to anything in the rule that says that? No. I think you're only liable for any penalties potential from the date you purchased it on. Everybody hear that? Again, I can't point to anything in the rule, but I think as a matter of law, you wouldn't be liable for anything before that. Anything else? Yes. Yeah. The new facilities that couldn't sign up for the air consent agreement because it wasn't available, I mean, they built after the sign-up period closed, then, yeah, all they can do is do the reporting process. There is no way for them to get into the consent agreement because theoretically they don't have any past violations to worry about. The tough one is the people who didn't sign up for the air consent agreement, even though they could have, and then now do they report? And I had that discussion with people, and I think most of them went ahead and reported. Not all. I think some have decided they don't need to report. But the difference now, from now back to when we signed up for the air consent agreement, is we clearly have an exemption now that says if you're below this level, you're exempt, but it also clearly says if you're above this level, you're not exempt if you're emitting 100 pounds per day. And that's the part I didn't cover. If you're at 3,000 head of hogs on a site, you don't get the exemption, but if you can show that you're not emitting more than 100 pounds of hydrogen sulfide or ammonia in a 24-hour period, even though you're above the exemption level, you're still not required to report. So those that didn't make the phone call, if they, say the monitoring protocols come back from the air consent agreement and show that maybe the level of 3,000 head where they think they hit the 1,000 or the 100 pounds, then you still wouldn't be required to report. So it's a bit of a crapshoot above the clear exemption level. Yes, we have a couple of questions here. I don't have any further word on that. I talked to some people from NPPC yesterday, and it was filed, but no, I don't have any further information on the status of that. I don't think. If anybody else does, raise your hand. Okay. Yes. Okay, the question was, some producers may not have made the phone call to DNR in addition to the call to the local people. They only called the local people. Yeah, I'd go ahead and make the phone call to DNR, have the information there that shows, I called Crawford County Courthouse on this day, but I didn't give you a call. I am now calling you. Gene, would you agree? I mean, I think you got to go ahead and make both phone calls. Now, I talked to somebody this morning or yesterday, I think it was this morning, that said when they called the DNR said, we will take care of contacting the local people for you. I wasn't aware of that, and and so anyway, I'd be, if that's what you were told, go ahead and write it down. That's what you were instructed to do. But I think at some point I might go ahead and make the call to the local people anyway, because the law says you're to report to both. Yes. Okay. And I'll see what Gene says to my response here. Did everyone hear that you called DNR, the local field office in Manchester, and they said they'd take care of contacting the local county or whoever? I think, since it was kind of a rush those few days, and Gene, I'll see if you agree with me, I might give her a call back and say, okay, were you able to do that? Do I need to give them a call? And it was very nice of them to help you out that way, but I think I'd double check it. Would you agree with what I just said? Yeah. Yeah. Again, there was a lot of phone calls coming in there, so they had a lot to do also. Okay, I know I'm over my time. Here's the website that's a direct link to some of the information that was emailed out. Just watch our website, other websites. We'll do our best to keep you informed of what's coming from EPA for further guidance on this. I didn't get to the rest of the stuff, and I'm past my time. I don't think there's anything earth-shattering in there. Manure management plans, you have to do the phosphorus index and all that. If you have any questions on any of that, I'll be around for today and tomorrow at Port Congress. Just pull me aside, and I'll be glad to visit with you. Okay?